Let's talk about intergovernmental immunities in constitutional law. This is short and sweet. Intergovernmental immunities and regulations. Number one, the full faith and credit clause. We know this. What is the full faith and credit clause? It means all states must give full faith and credit and respect the laws and the judgments of other states. And of course, their public records like marriage records, divorce records, child support judgments, and the like. Full faith and credit. All states must respect the one, that's right, laws, two, the judgments, and three, the public records of other states. Okay, the federal government has immunity from state taxation. The federal government has absolute immunity from state taxation. The states may not tax the federal government or its agencies or its instrumentalities. Okay, may states tax the federal government? No. May states tax government agencies? No. May states tax government instrumentalities? No. Okay, the federal government has what kind of immunity? Absolute immunity from state taxation. The states may not tax the government or its what? Agencies or its, that's right, instrumentalities. The federal government has what kind of immunity from taxation? Absolute immunity from state taxation. States can't tax the federal government, period, end of story. All right, what about state immunity? Sorry, well, states do have police power through the 10th Amendment for the health, safety, and welfare of their citizens, but states have no immunity from federal regulations. Therefore, the states have police power, but the federal government may not command the states or require the states to pass a law. The executive branch, okay, so actually let's talk about this in terms of commandeering. Okay, legislative commandeering. The federal government can't require states to pass a law. The states may not be required to perform executive functions. But there is no commandeering if the law just regulates state governments like it does private entities performing similar functions. Okay, so I don't have a good example of that, but legislative commandeering, federal government can't require states to pass a law. Now remember, they can condition grants based on compliance with federal regulations so long as they are clear and unambiguous and not unduly coercive, but they can't require states to pass a law. That is legislative commandeering, and it is unconstitutional. Also, states can't be required to perform executive functions. This has come up on the MBE in a question, for example, asking whether the federal government could require the state police to do anything. No, they can't. The state police cannot be required to perform executive actions. That is executive commandeering. So we have no legislative commandeering, no requiring states to pass laws, no executive commandeering, no requiring the states to perform executive functions. Okay, let's talk about the 11th Amendment sovereign immunity, which we have talked about before. So remember, a citizen can't sue the federal government directly. They can sue municipalities, they can sue officers, but they cannot sue a state directly unless Congress does what? They have abrogated state sovereign immunity. What's our perfect example? That's right, the 13th Amendment created a private right of action, abrogates state sovereign immunity for slavery and the badges and incidents of slavery. That's when Congress abrogates state sovereign immunity, then the state can be sued directly. Okay, you can sue a state official in their personal capacity, right? But so you can sue them for money damages in their personal capacity, right? Yes. You want to sue someone who is not acting in their official capacity? and they happen to be a state official, yeah, you can sue them. You have a private right of action against a private wrong. You can sue a state official in their personal capacity for money damages. What about in their official capacity? You can sue a state official for an injunction to stop that official from violating a federal law. Okay, number 1, 11th Amendment. Sovereign immunity means states can't be sued directly unless 1, Congress abrogates it, 2, the lawsuit is for an injunction to stop an federal official from violating a federal law, or you can sue a federal official for personal stuff in their personal capacity, and that means you can sue them for money damages. And of course, the state can consent to being sued. You might think the state never consents to being sued, but remember, if you show up in court or answer a pleading, you have consented. You just waived your sovereign immunity state. Okay, number 1, states can't be sued directly unless Congress does what? Abrogates it. What's our example? 13th Amendment, private right of action. The lawsuit is against a state. That's right, official for what? That's right, an injunction to stop the official from doing what? That's right, violating a federal law. You can sue a state official personally for their personal actions for money damages, right? And what about consent? Yeah, you can sue the state if they consent. And if they mess up and consent by showing up in court, answering a pleading or whatever, then they've waived that sovereign immunity. Okay, now what protects legislators performing their official duties? That's right, the Speech and Debate Clause protects legislators performing their official duties or speaking on the House or Senate floor. That's legislator immunity. But does that make legislators immune from criminal acts? No. A legislator can't be sued for their official duties, but their criminal acts, sure, you can sue them on that. Their torts, absolutely. The Speech and Debate Clause only gives legislators immunity for their official duties, like what they say on the House and Senate floor, on the campaign trail, or whatever. Judicial immunity. Okay, judges have 2 kinds of immunity. One is absolute, the other is qualified. Judges have absolute immunity from civil suits for damages arising from, guess what? Their official judicial functions. You cannot sue a judge for money damages in civil court if they are performing their judicial functions. Can you sue a Supreme Court justice or federal judge based on activities they're performing in their judicial function? Making a judgment, trying a case, writing an opinion, imposing punishment, fines? No. Judges have absolute immunity from civil suits for damages for things that are part of their judicial functions. They have absolute immunity. Okay, what about the qualified immunity part? Judges have qualified immunity for their non-judicial functions. When a judge is functioning in their administrative capacity, for example, by disciplining or firing an employee, the judge will have qualified immunity from that. In other words, they must follow the policies and procedures implemented by that office. They have qualified immunity. Administrative functions. They have absolute immunity for what? That's right, judicial functions. Okay, and finally, and last, we have executive branch immunity. The president has absolute immunity from, guess what? Just like judges, civil lawsuits based on their official conduct. The president has absolute immunity from civil lawsuits, private lawsuits, based on what kind of conduct? That's right, their official conduct during their presidency. What about their pre-presidential conduct? Well, that's not protected. Remember Whitewater. Bill and Hillary Clinton, while Bill Clinton was president, had to go through a civil suit for their pre-presidential conduct, the Whitewater scandal that arose before Bill Clinton became president. Once Bill Clinton became president, he was immune from civil lawsuits based on his official conduct, but not his pre-presidential conduct. We won't go into impeaching him or his sexual conduct. That's a different matter. Okay, so of course, the president and other executive officers can be impeached and removed for treason and bribery and other high crimes and misdemeanors. And we already talked about the impeachment power. Who votes to impeach? The House. By what? That's right, a majority. Who tries the impeachment? That's right, the Senate. And what do we need to convict? That's right, 2/3 majority of senators present. But what about criminal prosecution? Can the president and executive officers be criminally prosecuted while they're in office? No. They have absolute immunity from prosecution, but they can be prosecuted for crimes after leaving office. Okay, so in other words, the president and federal officials have absolute immunity from prosecution based on actions within the scope of their duties. They can be impeached or removed, but they can be prosecuted only after they leave office. Finally, federal prosecutors are a part of the executive branch. Federal prosecutors have absolute immunity and qualified immunity, like judges. This functions just like judicial immunity. Federal prosecutors have absolute immunity from prosecution based on actions within the scope of their official prosecutorial duties. They have qualified immunity for their investigatory and administrative functions, just like judges. Okay, absolute immunity for federal prosecutors based on actions that are what? Within the scope of their prosecutorial duties. And qualitative immunity for their what kind of functions? Investigatory and administrative functions. And that, my friends, is intergovernmental immunity.